and they're having a fight back and forth. I'm assuming Yak gets involved at some point in time.
My position would be the relevance.
Okay, well, I think on that, given that there has been suggestion that ATD only did what they wanted to do, and for particular results, I would overrule a relevance objection. Okay, whose phone offered the unsolicited math facts? Okay. So I assume you must have your setting on where you don't have to say, "Hey Siri," or push it. It just listens at all times. Oh, he said serious, and it thought it was. Okay. Well, hopefully that won't happen again. All right.
Oh, poor Brown.
Can I ask you?
Yes. And everybody else can break for their lunch.
Can I ask you a question?
Yeah.
A substantive question. I'm not so sure all these projectiles, shell casings have ever been introduced into evidence. I'm trying to check to make sure. But if they're not, then this witness is testifying as to doing work on an item that we don't see what he's looking at. So I'm voicing that objection. And I want to give everyone over the break, because if they're all in evidence, then he can identify it. But all he's doing is saying, I looked at a report number and here's what I do, without saying, yeah, this is the projectile or not projectile. The
shell casing.
Yes, sir. Yes, Your Honor. That's my objection.
The jury has seen photographs of each of the crime scenes that we're talking about. So I don't know if the objection is that we want to see the physical piece of evidence, but the jury has the information to know which crime scene. That's why we put that information in.
It's really not the objection. It's not a photograph. It's the item. He, meaning this witness, said,
the item.
You get the item, you run it through this NIBIN,
Mm-hmm.
and then you have to visually support it with his expertise.
Mm-hmm.
A photograph, you can't do that. My objection is, and it's best evidence rule,
You're
because
looking
of chain
for
of
the
custody.
actual shell casing.
Exactly. If it's not in evidence, I don't know. There seems to be a break.
Well, whether it's in evidence or not, is there a chain of custody objection or
custody, and he has no idea. He's reading a report. There's no evidence before him that he looked at to say, yes, I checked this out. I verified this. He's just saying it came back to NIBIN, and then I'm looking at another report, and it had a hit in another case.
okay? With regard to chain of custody,
So, Your Honor,
I would imagine if he hasn't, he can, if the questions are posed, establish that whichever one he is testing, that's crime incident report XYZ, how he got that and that came from. So
I'm just
given that
breaking
objection,
down
you need to
day
establish
45
that.
of Young Thug's trial right here.
and we did also with the crime scene technicians, if the court will remember, that was another reason we put them up, because they each testified as to what they collected.
Right.
And
So
what
as
they
long
did.
as he says, and I got it from whatever,
Literally just turned
Okay.
it on.
then I think that would satisfy chain of custody. But you seem to be making a second objection as well, that unless the actual shell casing is admitted into evidence, nothing he testifies to can be testified to.
I'm not so sure we're talking about the same item. He's saying a report.
People want my life.
Okay, well, I'm going to overrule that.
Can I have a continuing objection and make sure that, and I heard what you ordered, so I'm sure it'll be done, but that this witness actually said, yes, I received the evidence from this scene on this date, and I looked at it. Yes, that would be my objection. Otherwise, he's just reading reports, and that's what I'm objecting.
Well, I think chain of custody needs to be established as to each of them, given that objection. Okay. All right. See y'all at 1:30. Yes.
Remember, over lunch, it seems like Keith Adams is going to look through the actual papers that Love is looking at, and I am so curious because, Love so far has been careful not to associate any names with the question she's asking this witness. But if there's a piece of paper
Yeah, usually
that says anything like
the
this,
way I've been
which goes
noticing-
beyond what the NIBIN report would contain, it starts matching. I know it's really tiny on the screen, but this middle column is information that would only come from the police department, because it's associated arrestees. So this one incident that they talked about, one of them, where they didn't actually return anything, they had nothing returned, is this September 30th. It spilled into October 1st. Apparently, according to the state and what they have here on this PowerPoint, Shell Kell throws a punch and starts a fight with Duke at Magic City Strip Club. And they're having a fight back and forth. I'm assuming Yak gets involved at some point in time. We talked about it a little bit yesterday because Shell Kell had just been in custody and was released on the 21st. And he starts fighting 9 days later in the strip club with Martinez Arnold. And later that night, apparently according to the state, he links up with Yak to get some get back, right? So according to the state, he calls Kendrick, there should not be an S there, to assist in a retaliatory shooting of IF gang members. Police attempted to conduct a traffic stop on the vehicle occupied with Arnold and Kendricks near the residence to Kelvin Watts. After a short vehicle and foot pursuit, police apprehended both males. Police also recovered an assault rifle, handgun, mask, and bandana from the vehicle. So, in other words, the reason that there's no hit for this is because they recover these firearms as part of this traffic stop. Oh, hold on, I got Jesse talking to me in the other window. Let me mute him. And yet we've got this witness, we've got Love asking this witness about this date and this hit anyway, but really he's got nothing to really contribute if he didn't find a hit. So that was one of the objections that was raised, was because of this. And the reason there probably wasn't a hit is if they were on their way to do a retaliatory shooting, they wouldn't have used this firearm yet. Or they weren't on their way to do a retaliatory shooting and they were just driving in their car and had these firearms with them. So nothing had actually been fired from that gun in an active crime. So no NIBIN hit returning for that recovered firearm. So that caused a bit of a mess there, and I am very curious to watch the state try to lay out this incident. And again, we're going to go back to this. And in my opinion, I'm just going to start calling him a provocateur. Shell Kell, Kelvin Watts, again, throwing the first punch, yet another incident. Coming back to what I think Shannon Stillwell greatly called a generational beef. So there's that there. We'll flip back over here, get past Jesse. And are they both coming back? I know the jury's coming back at 1:30, but they've got to figure some stuff out, right? Before the jury gets back in. And Steve Kirkland, so there are some matches according to the state on something that has been excluded, and the biggest example I could think of is Quindarius Zachary. So give me a second, I'll flip back over to the slide that I'm thinking of. All right, so, and here's another one too. So this is Tariq Rivers. We heard about him yesterday. He's deceased, and I don't think someone's been convicted in his killing. But according to this PowerPoint slide, and again, this is the PowerPoint that's been excluded, in September 12th of 2015, there was a drive-by at Windsor Street. And I think we got asked about some of these numbers. It was hard to try to follow the NIBIN incident numbers while Love was reading them. But she did mention at least one match to Shell Kell, so it could have been this one. They end up recovering a weapon from Kelvin Watts in November. And the ballistics from the weapon they recovered then, apparently 2105, not 2015, matches this drive-by shooting at the home of Rivers. They also get an additional ballistic match from a shooting from May 9th, 2015 at Haygood and Martin. So if you ask me, it seems like these on the same day, 2 different shootings, and then on a different.
Damn, that's crazy. Ballistics matches weapon recovered from Kelvin Watts' arrest on 11/6/2015. Additional ballistic match from a shooting on 5/9/15 at Haygood Avenue and Martin Street. Tariq Rivers, YSL 30 deep member killed.
This extra shooting, the ballistics match that we have, according to the state, matches to shell count. So, I've seen you guys say it in the chat a lot already today. Before this Nibin guy, before Kilgore took the stand, it's the same names over and over, and they are not the ones in this courtroom. There was another ballistics. And what is the place's name? I'm going to call it Blue Shell on accident. And I know it's not actually Blue Shell. But there was a ballistics match, too, that I think matched the Hill Street. Let me confirm. No, okay. So, drive-by shooting at Springdale Road back in January. Then we have these pictures of Moontoon, Antrevia Smith, and Kelvin Watts all on this slide. And it just says up here in the corner, and I think this is not a very well laid out presentation. But ballistics show this incident has matching shell casings to 2 other shootings, Harwell Road and Pope shooting. And they excluded the blue flame. This was like something in 2014. And they had to strike the entire witness's testimony. It was a woman who was testifying about responding to the incident. And as she's testifying, the defense realized she's talking about this blue flame incident in 2014, and they have to approach, and then they strike the witness's entire testimony. So another ballistics match there, and it's not really clear what the ballistics match, who it ties to. They're not naming a name, but they're putting it on a slide with Moontoon and Kelvin Watts. So, my theory is that the state thinks that the ballistics belong to one side of this beef that was going on at this time. And one of the incidents, at least, is excluded as a match. But again, Moontoon pled out. So we have some ballistics. They don't really seem to tie into the people in the room. So... And again, I'm going to link to this PowerPoint. I think it's hilarious that it's excluded, and it's worth noting that there are things that are not correct in here, even down to spellings of people's names. So this is just something the state has put together. Really, the police and the prosecution have put together. So when you're looking through it, keep that in mind. This isn't like hard proven facts. It's just their way of trying to organize both the information they have and their theory of how they think it fits together. So this is that Operation Planters PowerPoint. Leave that for you guys to snack on over lunchtime. But yeah, so, and again, we got Darren Mills. Like, what, I don't need to say it, but If Gang. So, I don't know. It's all going to this theory that everybody was shooting at each other in furtherance of YSL. So some interesting stuff in here. I'm going to keep this handy and try to follow along with it when we get the witness backed up. It's a little hard to do, though. It's really tiny. And I said I'd pop back over here, because I'm really not sure when they're going to pop back in. And then big thank you, you guys have been incredible today. Dirty Old Sailor is just like dropping supers and gifts in the chat. Dropped 20, right? So he gifted 20 memberships. And then he's like, well, hold on, guys. Hold on. I see more people that didn't get a gifted membership. So then he dropped 20 more. Like, that's incredible. That's 40. He dropped 40 gifts. Then guess what? He dropped another 20. And this is all after he dropped 100 bombs. Like, crazy generous. So big thank you to Dirty Old Sailor. A ton of you in the chat are green today for the next 30 days because of Dirty Old Sailor. So if you want to drop some sailboats in the chat, this is the time to do it. Like incredibly, incredibly generous. Thank you for all your support and commentary to the channel, Dirty Old Sailor. Yeah, like everybody's looking green in the chat if I scroll over there. And thank you to the mods as well. I know the mods have been making sure people ask like the instructions on how to turn on that gift setting. Thank you so much to the mods. And then I wanted to catch this. Yeah, and don't forget too, Honeybee, the context. So Trivia was with Kel, and he and Summer argued at the Crystals, and he shot in the air, according to the detective who came on after Summer yesterday. And I thought it was their thing is out for everyone or just for them. And Down Detector compiles the hits of people looking for a specific category of thing.
Police report, and I removed any comments or commentary on it. And so other than the crime scene photos, like, which are I'm only gonna publish a few. There's a total of 24, but I'm not publishing all of them. And these two Instagram posts, this map and the discovery packet leak, those are the exhibits that I will be tendering through Investigator Griffin.
And are you going to ask anything about a later recantation or establish through him who ultimately got convicted or anything like that? Or is that the entirety?
So, Your Honor, I was telling this to Mr. Sharp, I am not going to ask him about the recantation or insinuate, because of the lack of clarity on that, that because of this leaked, that I'm not going to go down that line of questioning.
Okay.
I am going to ask him that one of the arrest warrants he took out was for the nickname Kelvin Watts. Kelvin Watts was not indicted on the case. Investigator Griffin is aware of that, so I'm simply going to ask him at the very end of his questioning, did you take out arrest warrants? On who? Did you ever come to learn if one of the individuals you took out an arrest warrant on was not indicted?
Right.
But I'm not going to ask him about convictions or trial.
Okay. Mr. Sharp.
I am satisfied with the plan as enunciated by Mr. Atkins, and I appreciate him talking to me earlier. I do have a couple questions that I just want clarity on. Am I correct that we still don't have the original letter that was written on his pad, on Investigator Griffin's pad?
Yep, so what's the authentication answer?
I have not seen one on Investigator Griffin's pad. I've seen that, I think it was Gwinnett County notarized letter. That's all I've seen.
Right, okay. So, and that's the alleged recantation.
Right.
And I'm not, if they don't have it, they don't have it. I get it. I'm just
Are
asking.
you talking about like the earlier apology letter or
Right.
whatever, which, I mean, presumably it got sent to the family if that was the purpose of it, but y'all aren't using that or talking about that anyway.
Right. I was just asking for clarity. Now, the other question, I'm a little confused about the social media post with the discovery on it, because and there's no evidence one way or another about whether my client has ever seen it before the discovery in this case. But I'm not sure if the state's planning on introducing that. What I remember seeing quickly when I was speaking to Mr. Atkins was everything was removed. I don't know what import that has. I get not having the comments.
That it's posted by somebody whose handle is YFN Nutlife, possibly? I don't know.
YFN Nutlife.
Mr. Atkins, I think there might be a relevance objection.
So, Your Honor, it's multiple relevance points. For one, that is significant in terms of, and some of there's other posts, some of which are handles that the state believes were involved in this incident. But I'm including just one. And number two, what has repeatedly came out in the trial, and the state has asked questions about paperwork, snitching, how that gets out. And this is just a clear example of someone literally screenshotting a discovery packet and putting it to the public. Obviously, the commentary is removed, but it's not favorably received, I should say that, in terms of why it's significant for a number of reasons, given the testimony of witnesses in this case, in terms of what people say from the state's position to police and what people say kind of repeatedly in court or things of that nature. So it has a multiple relevance point from the state's perspective. Primarily, the first one in terms of the handle of, again, this is, so that's it's part of that line of, that's the state's intent. We're back and forth.
I get it. I guess what I'm asking is that a post where your graphics team, in an effort to work with me, removed like emojis and things from the? Okay. I understand now. There's other versions of this that have
Commentary.
like the hawk or the bird and death to rats, or basically taunting my client. And I wasn't sure if what they're introducing was on its own a separate post, or they had redacted the threatening stuff.
Okay. Are you
so
satisfied now?
well, yeah. If this is what it was to begin with, then it is what it is, and I agree that the commentary on the side should be redacted. I just wasn't sure if we redacted the actual post.
Okay. All right. Well, thanks for working together to make this
Thank you.
less complicated.
You're welcome, Your Honor. And I'd like to also pass out to the court and defense counsel an exhibit list for Investigator Griffin.
Thank you.
Yeah, I don't know. I mean, it sounds like they're making sure they at least keep an arm's length away from getting into the contents of those letters. And Michelle, this is a great question. If this is supposed to be something that they take seriously when they want to, when Shannon Stillwell put something in a letter, is it something that they also use as
Your Honor,
exculpatory evidence for the defendants?
Out of an
in the
abundance of
Tierra Jones
caution,
case?
one other, there's no, in the entire statement, the November one, there's no one else on trial or Bruton issues, but I think out of prudence, because it is, I'm asking him about what happened that night and who he identified, but a limited instruction that, that statement can only be, it's not a confession of a crime. So, but out of abundance of caution, I would just want to think through if a limited instruction is needed to just anything that is said, would be attributed to only defendant Stillwell. There's nothing in what I'm asking Investigator Griffin that I think is on its face incriminating, but I just wanted to, express that with the court I was thinking through it myself of what the right.
Right, because you're not just having the are you not, is it correct that you're not just having the investigator say, Mr. Stillwell identified two people who he thought, or who he saw at the JJ's Chicken, in the red car, you're having them say, the investigator say, and it was these two people, or these three people? I don't know.
He will at least say that he ended up taking out arrest warrants, and some of those people are the same. And so,
okay, but is who gets identified going to be, who Shannon identified going to be elicited from the investigator?
Yes. In terms of when you interviewed him on November, who did he
say he saw at the JJ's in the red car?
Correct, Your Honor.
And he will say these names.
Correct.
Your Honor, I hate to do this. I'm looking at this proposed exhibit 28DD, SDP.
Mm-hmm.
Okay, that was a mouthful.
I don't have a problem with the state eliciting from Investigator Griffin that there were social media posts with the discovery identifying Shannon Stillwell as a witness, and people were saying horrible things or whatever the state wants to elicit. The problem I have with this exhibit is that it has a narrative at the bottom that kind of it testifies to.
I haven't seen it.
It's okay. Matt.
Mm-hmm.
Yes.
Yep.
Yes, I don't know. And Michelle, you guys remember too, there's still the authentication issue. They don't have the original apology letter, and well, they didn't have the apology letter like turned over or whatever. But then for the second letter, they have this notarized copy
All
because
right.
it was used in another case.
The issue is in.
So is that really authenticated? And what was the context in which he wrote these things? He was apparently hospitalized, may have been
The problem
medicated for
I
pain.
have with it is
first letter.
when it gets into when asked why he did not provide me with this information when first interviewed Shannon, Jackson advised he was concerned about retaliation against his family, particularly his grandmother. That gets to inadvertently we're now introducing a picture from discovery, and that's testimonial. And the problem is, I'm arguing for myself, but I actually think probably the other co-defendants have a stronger argument because it's not their statement, and it affects them as well.
Yeah, I agree.
Your Honor, if I redacted the words, so it just has and I could ask Investigator Griffin, to elicit that in this post was contained, I'm not going to have, the jury won't see or read what's actually written. It'll be a photograph, and it says Shannon Jackson, injured rear passenger. And then it has Investigator Griffin's, name, the case number, but that paragraph on the bottom, I can redact that.
I think that's probably needed.
Yes,
if
Your
you
Honor.
want to use that.
Yes, Your Honor.
All right. Now, with regard to everybody else, there's a Crawford issue. So, I'll hear what anybody else has to say about that.
We are objecting on behalf of Mr. Williams to the admission. I spoke also with Mr. Atkins before this honorable court began. He'll correct me if I'm wrong. He agrees with that too. So Mr. Atkins stated that he's going to request a limiting instruction. I have not done a limiting instruction. If you want me to do it, I will try to do it, but I don't know what a limiting instruction would say. It gets very complicated because of the way that the case is charged with all the overt acts. This is not an overt act, so it's better than like the statement of Mr. Kendrick, let's say, or the guilty plea of Mr. Kendrick or Mr. Ryan, but
it's still
very hard to imagine somebody.
No, I mean, yes, if we need to come up with some kind of a limiting, if this evidence is going to come in the way that it's been discussed, I think we need to come up with a limiting instruction that is appropriate to give. And we need to, if Griffin's our first witness, we need to do it in the next 10 minutes.
He's our second witness, Your Honor.
Okay, well, still, we're going to be...
Shout out to them for
I don't
being
know that
prepared.
anybody's going to have the luxury of being able to focus on a limiting instruction once we start the trial for the day. So if somebody can come up with something now, that would be wonderful.
Yes, Your Honor.
Mr. Hugh and the rest, I think, probably speak for the rest of the defendants. We join in that request as well.
Well, Your Honor, we join in the objection, and we don't think that a limiting instruction is going to be able to fix the issue. So I just want to make sure, for the record, we object to this.
Okay, thank you.
Your Honor, I will work on crafting a limited instruction that I think for the sake of both defense and state should be brief, because what he's stating, if that limiting, because he's not directly stating anything against any defendant in the courtroom, he's discussing people who are not in this courtroom that the state believes are not friends or were part of in any way, shape, or form, any defendant in this case. I don't know what exactly would be gleaned against another defendant from what I'll be asking.
Okay, well, I mean, you, the state, must be presenting it for some reason to try to establish your story of why these defendants are guilty of the crimes with which they're charged, or you wouldn't be presenting it. So,
Yes, Your Honor.
I mean, that being the case,
Exactly.
and I think it is to show your theory of the back and forth between the whomever rival gangs.
Correct, Your Honor.
And so that concept, this tends to further develop and further establish that concept. And so if there isn't a limiter, then it gets considered against everybody. So there definitely needs to be some kind of a limiting instruction, and if it's not sufficient to.
Hilton didn't grasp that yesterday. Or maybe
let
she
the
chose
jurors
not
know
to.
what to do and not do, then, I mean, it has to be. Otherwise, we can't let the evidence come in this way.
Yes, Your Honor. I will work on finding a
Okay.
limiting
So
instruction.
how
to provide
long is
some-
our first witness going to take?
Your Honor, I believe that first witness should be 45 minutes to an hour,
Okay.
at least is my
Okay.
prediction.
Okay. Well, then I guess we'll take that witness and then take an early break and figure out the limiting instruction. Okay. Are we
Joe
adjourned?
Steven.
Is there going to be any objection to the, I guess it's what, 20 you said, photos on the wreck itself, now that that one has been taken out? That was the only one that there was objection to, I guess.
No objection on
All
that.
right. Okay. All right,
Oh, we gotta
let's
squeak.
get the
We gotta do
jury.
a banner. And guys, we
You have
talked
your
about this
witness